This is the Mobile Home Park Lawyer Podcast with Ferd. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd.
Welcome back, Mobile Home Park Nation. Here tonight, continuing my discussion from the last episode on rezoning variances and conditional use permits. These, again, are ways to maximize and utilize the property to the fullest, despite opposition from a municipality, and really to try to get away from or get out of some sort of code restriction. Oftentimes these code restrictions are not actually valid or enforceable, but sometimes it's better to play the city's game and go through the hoops of a rezone or variance or a CUP rather than a lawsuit. I fight these issues quite a bit. The merits of the case on zoning are very, one, jurisdiction specific, and two, fact specific to the particular instance. So it's really hard to give a blanket answer to somebody. Oh yeah, you'll win. It's like, well, I haven't read the code in the city of X. I need to find out. I haven't looked at the case law in the state of Y and the district of Eastern. I'm dealing with one in Missouri right now, where I live, and is where I host my practice. And there's a really strong Eastern District of Missouri case on setbacks and ability to replace homes and grandfather status. But a lot of cities, frankly, don't want to hear about it, and they want to fight it, and especially cities that are like, well, we're in the Western District of Missouri, or we're in the Southern District of Missouri. I'm like, so the way it works basically is if it's from a different district, it's not Supreme Court, it's not binding. It's persuasive case law, but it's not compelling to the point they have to follow it. This is why you see the United States Supreme Court, all those cases that they hear, there's a justiciable controversy that different Court of Appeals districts have ruled on this in different ways, or there's a new and distinct fact pattern. So anyway, all this stuff is very fact specific and case by case specific, but it's important to at least know your rights and know the processes. So we talked about the rezone on the previous episode. I may touch on that some more, but I really want to focus here on variances, and we may get to conditional use permits in this one as well. A variance, I tell people, it's basically an exception to the rule, and it can't be an exception to the rule as like a favor to me or you. That's basically spot zoning. It's a one-off, inappropriate exception. But a variance, it comes from an administrative body. A lot of times I'm typically from a Board of Zoning Adjustment or Board of Zoning Appeals, which is a quasi-governmental body that, basically they're appointed citizens who really like dealing with this stuff and, really care about their neighborhood, their town. Typically they're not paid. They're not elected officials. You're not allowed to lobby them, meaning go meet with them and pitch your case like you can with the city council. So it's definitely a different process. You got to go through, like a rezone, you got to go through public hearings and you got to pay a fee and provide documents, but it's not that onerous a process. It's just variances are supposed to be rare. In practice, they're given out, frankly, more than they should be, but it's basically an administrative decision or discretionary move to waive some zoning requirement. So, for example, in mobile home park world, oftentimes there's a code provision that says mobile homes must have the following setbacks from both perimeter and internal to the other buildings. So let's say, for example, that the external perimeter setback says 20 feet on the rear and the sides of the property and 30 feet in the front of the property, which is typically the main entrance on the busiest road most times. Well, if I have a mobile home that is currently 29 feet from the front street, I'm grandfathered in if my home was there before the 30-foot code provision. But let's say that home burns down. And I love the home. It was a 1680, beautiful home with the hitch end elevation and planter boxes and pitch roof and porch model and all kinds of great stuff. And I want the same model. Well, I can't put it in the same spot because this new code. Now, you could argue, and I will argue all the time, that I'm just a parking lot as a mobile home park, and I'm immune from the setback requirements as it pertains to perimeter setbacks, so long as it's not a fire code issue or a public safety issue. Which, if it was 1 foot from the street, it'd be a public safety issue because cars could hit it. But 29 to 30, I would frankly argue that that the code doesn't apply to me. But the city tries to put the screws to me. It might not be worth suing. The juice isn't worth the squeeze, perhaps, to file a lawsuit to get 1 foot. Maybe I just got to suck it up and buy a smaller house. Or I go for a variance. And the variance is me saying, hey, look, I acknowledge that the code says I can't bring a home within 30 feet of the external perimeter setback, but I had one there at 29. I really want the same home. I got it from Grandma. It's really near and dear to my heart. Can I have an exception, bring the same home and have 29 feet? Well, that would be an area variance. Basically, it's meaning an exception based on the district code relative to what other landowners have. So if the similarly situated landowners have a certain right and restriction, I'm supposed to have the same. The variance is like, look, I'm hard. I have a hardship. My situation's worse, and the way my situation's worse may be an odd configuration, dense lot, a corner lot. Basically, I asked for a variance when it's like, hey, look, I've got an unusual and quote unjust, inequitable situation, and I didn't create it. So in my example of my 30-foot home, my home that's 29 feet away in a 30-foot setback, if I put in the roadway in a manner to put the home 29 feet away because I like the view of the ocean from there or something, well, I kind of created that. But if the roadway was already there and it was designed that, look, we got a house, then we got a road, and then we got another set of houses at the end of the back property, well, it's kind of already shoehorned in there. That was the previous guy. That was the guy that built it 50 years ago. So I would say, look, I need a variance. And there's two types of variance. There's area variance, which I'm talking about ad nauseum, and there's a use variance. Use variances are pretty rare. And that would be like, look, I'm in a residential neighborhood, and I'm supposed to do single family, but I really like train cars, and I want to build a little mini train set or something, or I want to put a gas station in a different use than is permitted in my R1 zoning classification. Those are rare. Some cities will have them make you go down the conditional use process instead. So I'm going to focus on the ones that are more MHP specific here, which is obviously the setback variance. And interestingly, mobile homes are not considered structures unless they're legally affixed to the real estate, which basically is an abandonment of the title. And you go down, record. I've done it once or twice. You got to go record the information on the home at the county recorder deeds office, and they basically forfeit your mobile home, and they give you real estate, and you get taxed for ad valorem purposes by the county appraiser as real property. Doesn't really happen much in a mobile home park, but it makes the financing easier, and it makes sense to do it if you got a mobile home out on 10 acres and you want to put it on concrete blocks and everything like that, but not typical in a mobile home park. Anyway, the variance is supposed to be something, again, unusual characteristic that I didn't cause. And technically, the variance should be something that's going to help comply with the comprehensive plan or the zoning ordinance. Frankly, it doesn't happen a lot like that. These cities and these board of zoning adjustments give out variances sometimes for seemingly no reason. But the purpose of it is to set me up in a fair, equitable situation. So one thing that's helpful if you ever ask for a variance is to look and see if anybody else ever asked for a similar variance. So if the other parks in town asked for a similar variance and received it, you better get it. If the other parks asked for it and did not get it, you probably shouldn't. And if you do, you got lucky and it's pretty much spot zoning. So you got to work with the city. You got to prove that, look, this is necessary because I've got a problem that I didn't create. I bought a park in Illinois one time, and the park predated the city. So the guy that sold part of his farm for the park, they carved out exactly the size they needed for the horseshoe road and 50 some lots, and the homes were put in literally up against the property line, which was a fence. I mean, some of them 2 inches away. Well, then the surrounding farmland was sold off. City park, neighborhood, all that. So I wanted to replace some of these homes. Well, they're 2 inches from the property line. The current setback is 20 feet. And fire code is also not going to be my favorite. So I had to go to the city and say, look, I need a variance from the current setbacks because practically I cannot reuse these lots. These are 60-foot homes on a 60-foot, 2-inch lot. If I got to abide by a 20-foot setback, I'm talking 40-foot, 2-inch homes. I'm screwed, right? I can't use those. I can't do anything with them. And there were no structures or buildings on the adjacent property within the fire code. So I said, look, I'm not asking to put the homes end to end 2 inches. I'm asking for the external setbacks to be 2 inches. And I had to measure every single lot and take pictures of, look, this is lot number 1, it's 2 inches. Lot number 3, it's 8 inches, and so on, and go through the city process in order to get a variance. And I was able to prove, look, this is a really tough hardship for me. I can't reuse these lots due to frankly, the market of selling mobile homes, but also there's the common size of mobile homes today. So it was a big problem, and I didn't create it. And if you enforce the setbacks against me, like you do all other similarly situated property owners, like the mobile home park literally directly across the street, if they don't have the same perimeter problems, I'm going to be up a creek, right? They're going to be smoking me on home sales. So anyway, I found a city zoning administrator that was amenable to that request. But that is a good instance of when you should get a variance from an area variance. But again, they're pretty rare. They're supposed to be rare. And it's just another way to try to maximize and utilize your property in the face of, a code restriction that you can't comply with. Till next time, God bless.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.